Christ is King.
All right, cause number 23129-303 and 23129-304.
Aren't you going to take a seat?
No, I'd rather stand.
Well, it's your hearing, sir.
Is it okay if I stand? Is there something wrong?
Why do you have to stand so close to him?
The sign there that says no standing.
Oh, well, okay. I just know I was subject to those rules. I didn't agree to it. Anyway.
Okay, so there's a bench warrant.
You know, I'm just going to take the seat.
Thank you.
Sit right here if that makes us a little more comfortable.
Is it uncomfortable if I stand up, Your Honor?
Well, depends on how you're going to act or behave today. Okay, so you failed to appear for court multiple times in this case.
Your Honor, just for the record, the named defendant is Actual Property, a registered trade name.
Oh, here we go.
And the case has also been certified as a fraud. I have court certified documents to prove that. That should be on the record. And that's the reason why it was certified to be a fraud, because the plaintiff is a foreign-owned private corporation, of which I have no contract with, and neither does the registered trade name. And the registered trade name has been used without authorization and permission, and there's an act of identity theft, and that's probably one of the reasons also why the state has acquiesced that the...
And there it is, the classic sovereign citizen declaration. I'm a foreign sovereign of the corporate entity known as the state. For those who don't know, this is a common pseudo-legal argument where defendants claim that governments are private corporations and therefore have no authority over them. It never works, not once, not anywhere. The judge, to her credit, plays it cool. She quashes one old warrant but moves forward with the real issue, that this man was sentenced to 4 days in jail and never showed up. What's his excuse? He says he tried to deliver the defendant, as in himself on paper, but the jail refused. Yeah, no kidding, they refused.
One more piece of information. I am a foreign sovereign with respect to the privately owned foreign corporation known as the state of Washington.
Okay, so on the 9304, I am going to quash that one. He was in RALJ appeal status, and so I'm going to quash that one. But I do want to hear from the state on the 303 matter.
Yes, on the 303 matter, Mr. Haywood was sentenced to serve 4 days in jail. He failed to report to the jail on June 29, 2023, and we're asking him to be taken into custody to serve that time.
No objection, Your Honor. I actually contacted the jail to make special arrangements to deliver the defendant with the special arrangements to not damage the paper, and the jail refused. So I attempted to deliver the defendant, and objection, the state has no standing as they are representing a privately owned foreign corporation, and the prosecutor is not licensed to practice law in this country.
Okay, so I think it's the 303 that he was convicted and ordered to do jail, and you believe that he didn't comply with jail because there's a docket entry that said defendant complied with jail. Maybe that was an error.
That was probably my attempt to deliver the defendant to.
Here's where it gets messy. The defendant argues that because the jail refused the paper, he technically did comply with the sentence. But legally, compliance means physically serving time, not sending documents or trade names. The prosecutor and judge are trying to remain professional. But you can almost hear the disbelief in their tone. This is like arguing you paid your parking ticket by mailing a drawing of cash. Quick question for you. If you were the judge here, how long would your patience last? Would you keep reasoning with him, or would you send him straight to serve those 4 days? Let me know in the comments, because this case tests every ounce of courtroom composure.
He had not, as was the state's understanding, he had not served the jail time.
And just to clarify, the defendant only exists on paper, just as the plaintiff only exists on paper. The jail refused the paper, and here we are today. And the state still hasn't proven standing yet, by the way, as well.
So, Mr. Haywood, it doesn't look like you did the sentence on the 303 matter. And so I am going to quash the warrant. However, I am going to have you serve that time.
Okay, well, I'll deliver the paperwork to the jail. That's fine. I tried to once before, but they refused it. And just to clarify, I'm not the defendant. There is nothing on there, nor is there any testimony from anybody as firsthand witnesses under penalty of perjury that I am the defendant. And I've uploaded plenty of documentation to prove I'm not the actual defendant. That is a registered trade name, matter of public record, and registered with the state. So if you want me to serve some jail time, then we're going to need to change who the defendant is, because I'm not the defendant.
All right, so can you upload a new commitment?
Yes, Your Honor.
And the reason they couldn't put my name on there as a defendant is because I'm a foreign sovereign with respect to the corporate entity known as the state of Washington, of which I have no contract with.
At this point, he's doubled down, claiming he has no contract with the state of Washington, and therefore the court can't touch him. It's the legal equivalent of telling a cop, "You can't arrest me, I don't consent." But here's the truth. Jurisdiction isn't optional. Once you commit an offense within a state, you're subject to its laws, period. And when the judge finally says, "the land of make-believe," that's her polite way of saying, "Sir, you're living in your own universe." I mean, credit to her for keeping a straight face. Most judges would have snapped by now.
Respect to the 304 matter, which is still pending, what's your position on the warrant, Ms. Fredenberg?
The state was going to ask for that warrant to be served.
Objection to jurisdiction. The state has never proven any jurisdiction and has no jurisdiction or standing. So any requests or statements from any representative from the state are a nullity and a fraud. If jurisdiction is challenged, it must be established on the record. And it hasn't been, and it still isn't. You can do it now if you like, if you can.
Okay, so Mr. Haywood, you failed to appear many times in both of these matters, had many warrants quashed, and to be perfectly honest, I'm not confident that you're going to come back to court given the history here of failing to appear.
I will agree to come back to communication between the acting prosecutor at the time and myself. I have plenty of emails. So in one case, he said he was just going to reschedule with the judge. I told him, reschedule whenever you want. I'll go ahead and be there, and I'll bring the defendant with me. And next thing you know, there was a warrant for a failure to appear. So there's been plenty of fun and games with the acting prosecutor at the time. So it wasn't just a matter of not bringing the defendant to the court. The prosecutor was intentionally sabotaging the scheduling process.
Well, the prosecutor doesn't handle scheduling, the court does. So the court ordered you to be here, and then you weren't.
This is where the fantasy meets reality. The judge lays it out plain. He had a trial, he was convicted, and he was sentenced. End of story. But he's still insisting that he's not the defendant. The irony? He keeps showing up to court on behalf of the defendant, which is himself. It's like arguing with your own reflection and losing. The judge, though, is done playing games. She issues a new commitment so that the jail won't refuse the defendant this time. Translation: whether you think you're paper or person, you're still going to jail.
So,
Objection. The court ordered the defendant to be here. I am simply bringing the defendant to the court to help try to solve the problem. The fact that the registered trade name remains as a named defendant is an act of identity theft and fraud, and that's probably why the state has acquiesced that the case is a fraud. I have the documentation here with me today in case if they decided not to upload it to the court record.
well, you had your day in court on the 303 matter. You had a trial. You represented yourself. Or the defendant, whichever way you want to say it, but you represented the defendant yourself, and you were convicted, and you were ordered to serve 4 days in jail. You didn't do that. And so
The defendant was ordered to serve 4 days in jail, and I attempted to deliver the defendant to the jail, but the jail refused.
okay, well, I'm going to make sure that they don't, because I've done a new commitment for you today so that they won't refuse for the defendant to serve that time. I'm going to serve the warrant, and so we need a pretrial date, Madam Clerk.
There's no jurisdiction yet been proven or standing. Are we going to continue? That would be an act of fraud and treason.
Your Honor.
That's a felony. That's an arrestable offense.
I put both of them in one of four.
Well, we don't need anything on the 303. He's just gonna serve a sentence.
Okay.
We just need the 304, and
Yes, I
I
have
see
the
that.
defendant here with me today. You can take him to the jail.
Going to be September 13th. We probably need to change that since I'm taking him into custody. So do we have anything in August?
Excuse me, Your Honor, are you testifying that I am the defendant under penalties of perjury?
I'm not testifying to anything.
Good. And here's the defendant right here.
All right.
Your Honor, we can do August 24th at 10:30.
All right, I can change that.
Thank you, Your Honor.
So August 24th at 10:30 in the morning will be your next court date.
I will be here with the defendant, no problem.
You're going to serve those 4 days, and then you'll be released, and nothing more will happen on that 303 case. You'll be done. And then this case will be heard August 24th at 10:30 in the morning. If you change your mind about representing yourself, then you can ask for help if you want it. If you don't want help, we don't have to have it. So we'll see you in August. I'm going to have you take a seat right over there.
I will be here for the defendant August 24th. Would you like me to deliver the defendant to the jail?
I would like you to sit over there
Is there any
with
standing
the
or
defendant.
jurisdiction chosen, proven here yet?
Please go take a seat.
Okay, so let the record reflect no jurisdiction established.
Okay, please go take a seat. Sonia Sesko, customer 2310242. Mr. Haywood, sit down.
Am I obligated to follow these rules?
You are going to sit down right now.
Do you have any jurisdiction? I don't believe you have any jurisdiction that's been proven yet.
Please sit down.
Are you threatening me with violence?
I'm asking you to sit down.
You don't have authority over the defendant. He has no authority.
And there it is, the final act of the sovereign citizen saga, attempted courtroom exit. He stands up, says he's got things to do, and tries to walk out while in custody. The judge immediately warns him that leaving would be felony escape. And suddenly, he sits right back down. He even tries to spin it as avoiding violence. Sir, you're not Gandhi. You're under arrest. This part always gets me. The man still insists the defendant isn't him, as deputies prepare to escort him to jail. Talk about poetic justice. Reality always wins in the end.
What are you doing?
Mr. Haywood?
You're escaping?
I got things to do?
No, sir.
What?
You are in custody right now. If you leave the courtroom, it's a felony escape.
That's a felony to put me in custody because you have no authority or jurisdiction or standing. You got some proof of
Okay,
that?
well, we are all being recorded, so if you leave this courtroom, it'll be a felony escape charge. Your
So you-
choice.
Okay, well then, I guess in the best interest of peace, in regards to your violence, I will go ahead and relax for a minute, but let's get with it. Got it?
What was that just thrown?
Car keys.
Do you know that person?
Yeah, they're my voice.
Okay. All right. So thank you. Mr. Haywood has been very disruptive. He tried to leave the courtroom once he was placed in custody. So just FYI, be careful with him.
So, give me a break. Can I just see just need to see it, thank you. Can I see who's being put into custody, please? I just need to see the name. I just need to see the name of the person.
We're here today
No, it's not me.
Who's that right there?
The name is saying it, but that's my registered trade name. I got all that documentation right here.
Okay, good. So we're going to take care of it.
Okay. Yeah. Well, this is the defendant technically.
If you want that, I can go with you, put everything private.
Hold on 1 second. Well, that's taken care of.
We can figure it out and get the right name.
Did she file a notice of appearance?
I will make sure that she does, Your Honor.
Okay. Yeah, sorry, I haven't had enough coffee yet today. So yeah, no, you've got Ms. Bradshaw, so that's fine. You don't need to do those forms. But she does.
And that's a wrap on one of the most bizarre courtroom showdowns we've covered. In the end, the sovereign citizen known as Mr. Haywood learned the hard way that legal fantasies don't hold up under real-world law. The judge remained calm, patient, and precise, ultimately ensuring justice was served, literally. Sovereign citizens love to argue about jurisdiction, but the truth is simple. If you break the law, the court has power over you, no matter what you call yourself. What did you think of this one? Do you think the judge handled it perfectly, or would you have taken a tougher stance? Let us know in the comments. And if you found this breakdown as shocking as we did, hit that like button, share the video, and subscribe for more jaw-dropping courtroom moments every week.